when the moment the matter comes to court, it must be handled. We are not going to chase away anyone. However, of course, as you say, I think these cultural matters should be mediated. I don't know why you always want to run to court, because mediation should be the thing to go. You have elders. You have all sorts of, you even have elders from other communities. For example, you can get the interreligious council to mediate you, and maybe you strike a settlement. I know Ikubanya also, the other side, they have also been here. The last time I checked, they had 18 cases in this court. That's also a cultural institution, I think, of the Bugwere. So you can't start sorting cultural matters in courts here if you can mediate them. Of course, when you come, we shall eventually decide who is right and who is wrong. But ideally, you should settle these matters yourselves. Then around to use the trained mediators settle some of the cases in court. The Court of Appeal is leading by example in the area of mediation. In the year 2024, the court conducted 166 mediations, out of which 100 succeeded. I hope the lawyers are listening. We conducted 166 mediations, out of which 100 succeeded. One of our registrars will be conducting pre-mediation in 10 civil appeals files between today and Wednesday, 10 September 2025. Where parties agree, one of their lordships will conclude the mediation process. So at the moment you agree, you will appear before one of the justices here and sort out the matter. Therefore, mediation is welcome even at appellate level. We invite you to embrace and promote it. At least conduct one settlement week in each quarter. Each judicial officer can conduct mediations in his or her court on particular days of the week, and then advocates as well. This will help us to reduce on the caseload at the stations using cheaper, acceptable, and quicker methods of resolving disputes. Alternative dispute resolution is now the way to go world over. Countries like United States, United Kingdom, Denmark, South Africa resolve most of their court cases through ADR. ADR is aimed at delivering justice to the public in a speedy and fair manner. Involvement of the people in settling their disputes using these mechanisms makes them appreciate and accept the justice system. We invite all stakeholders to embrace ADR. This will reduce on the public complaints relating to delays in the delivery of justice. We are grateful to the advocates who have promptly filed their written submissions in preparation for their sessions. We thank the other justice actors that have enabled this session to take place as planned. I think, as you are aware, the Court of Appeal usually sits in Kampala. However, in a bid to bring the Court of Appeal nearer to the people of Uganda, we decided to hold regional Court of Appeal sessions to ease physical access to justice for our people in the different regions of the country. For quite a long time, priority for Court of Appeal regional sessions was given to the criminal appeals. However, various stakeholders requested that civil appeal sessions also be held at regional levels, just like the criminal appeal sessions. We listened to the request as top management of the judiciary and considered the stakeholders' concerns. Consequently, last year, the Court of Appeal started holding civil appeal sessions at regional levels. Thus, this is the 5th Court of Appeal civil appeal session to be held outside of Kampala. The first one was held in Iguru from the 25th to the 8th of September 2024. The second one was held in Barara from the 11th to 13th of December 2024. The third was held in Jinja from the 24th to the 6th of March 2024, and the fourth was held in the fourth quarter from the 25th to the 6th of June 2025. Today, we are glad to be holding the first ever civil appeal session here at the Bari High Court Circuit in the eastern region of Uganda. These upcoming sessions assist litigants to reduce on transportation costs as well as other litigation costs that would be incurred by moving to get services of the Court of Appeal in Kampala. The regional sessions of the Court of Appeal are a short-term relief. The long-term solution is establishing regional circuits of the Court of Appeal. The Judiciary Council recently considered and passed the draft regulations establishing the circuits of the Court of Appeal at Gulu, Mbarara, Mbale, Masaka, Fort Portal, Arua, Jinja, and Mubende. We secured funds for construction of the Court of Appeal building at Gulu and Mbarara, where we have already done groundbreaking. We are glad that Mbale identified land. Of course, there was a delay, but I think delayed to identify land, where the other two had given us land much earlier, so that's why they were prioritized. But now that you have identified land, we shall begin construction next year. Otherwise, we in the neighborhood. Obviously, I was not even going to hesitate to go to Tororo because they were willing to give us land. After all, it's the same region. But now that you redeemed yourselves and gave us land, we shall begin construction next year. This expansion is in line with the judicial transformation agenda of enabling physical access to justice to all Ugandans. Now, we hope that when we construct the Court of Appeal here, then you will have regular sessions. And that's what you should be clamoring for. The lawyers around here, you will become kings within your own region. So that's what we should be clamoring for. So, and when we begin the project, to make sure it succeeds, you should go all get interested, whether advocates or local leaders, ensure that the project moves on as smoothly. We are mindful that Mbale High Court Circuit, like other High Court circuits and divisions, is faced with the challenge of case backlog. However, we commend the judges for the good work done at this station in managing their workload. And yet, our workforce is still limited. This makes both physical and actual access to quick justice difficult. Efforts are being made by the appointing authority and the judiciary to resolve this issue. Earlier this year, we got 8 new justices of appeal to mitigate the challenge of inadequate human resources. The appointment of 8 new justices of the Court of Appeal at once is a clear indication of the government and the judiciary to address issues of inadequate human resource. Therefore, currently we have 20 justices of appeal. We are optimistic that we shall get more to reach our statutory ceiling of 35 justices of the Court of Appeal, Constitutional Court. This will help us spread regionally the services of the Court of Appeal. We are glad to note that the Court of Appeal held a criminal appeal session here from the 10th to 12th of March 2025, and we are here once again after less than 6 months. The court managed here 26 criminal appeals, and the judgments in the 26 cases, case files have all been delivered. In this civil appeal session, 25 cases have been cause-listed. Our resolve is to clear the case backlog in the judiciary. This session is a clear indicator that we shall do our best to realize this goal. The judiciary of the 27th June 2023 launched an alternative justice strategy by which we intend to increase the application of our African traditional methods of settling disputes across the country. These methods are cheap, quick, and acceptable means of settling disputes. And I encourage the advocates to embrace this. Our mediation experts have been conducting mediation trainings in this region for quite some time now. In 2018, the week-long mediation training was held here in Mbale at Mount Elgon Hotel and Spa, where 100 mediators were trained, including judicial officers, civic and religious leaders. Last month, a training for mediators was conducted at Wash and Wheels Hotel with a goal of enhancing the capacity of mediators. And the colleagues, when we hold these trainings, they are intended to ease administration of justice. I know, as lawyers, right away from the time we were in law school up to the time we finished LDC, we never taught mediation. All we taught was litigation. In fact, I remember when we were doing art of advocacy at LDC, they would say, how do you cross-examine a stubborn witness? How do you cross-examine a denying witness? So, would be concentrating on cross-examination, re-examination. That was our specialization. Now we are telling you that mediation is the way to go. Actually, in some countries like United States, I went with the Chief Justice in the paper in university in the United States, and we were taken through both the federal courts and the state courts. They solve 95% of their cases through mediation. Now, surprisingly, they told us that they copied mediation from Africa. Now, for us, we copied their legal system and we've dumped ours. So, I think we are always copycats, and that's our nature, I think, maybe. But I think advocates, as well as religious leaders, I'm glad here the one who is mediators is a bishop. We need to have mediation as a central focus so that litigation becomes secondary. Because even in mediation, you can negotiate your costs and all that. It doesn't have to be that that when you go for mediation, that you lose out. And that is I also had that when I was an advocate myself, not long ago, by the way. I also had that feeling that when you mediate a case, you compromise your costs. And yet, I've seen the cases we are mediating. Actually, that doesn't happen. Yeah, of course, it's a give and take. You may, instead of getting a whole bunch, you may get a cluster. But still, it's okay. No, I think they had sanctioned them, but they were proceeding to indict them, meaning that they would request for their arrest because of the adoptions they had conducted, and which ended up being controversial. I think some of them where they harvested organs from the children, and then there were a number of course, I got a report which I can't share with you, it was confidential. But when they were indicted, before they could be indicted, we had to engage the embassies in Kampala. And one of them was the American embassy, because it is the one, because remember, even when you finish these intercountry adoptions, these children must leave the country. And to leave the country, they must get visas. Now, so here we are, the embassies are saying, no, your adoptions are problematic. In fact, we were forced to review all of them. They had a list of those they were uncomfortable with. We reviewed a number of them, and indeed there were issues. So, eventually, out of the meeting of the ambassadors, we agreed that we shall have these intercountry adoptions handled in Kampala to give confidence, and that even the judges handle them would be selected. Not every judge even in Kampala handles adoptions. When she was at the family division, she was the one handling adoptions together with another justice only, and I would communicate with the embassies. When I appoint them, I would say, from today onwards, the person who will be handling adoptions will be justice so and so. One time, another justice I had posted there handled an adoption, and when they received the papers, the calls I received. So don't take it lightly. It's really not that we don't trust our justices here. It's a negotiated issue. Otherwise, it makes no sense for you to have an adoption hard here. You get an order, and the order cannot be implemented. So it would be an effort in vain. So you have to bear the cost. In any case, a person who wants to adopt the child to take him out of the country should be able to afford transport to Kampala. If that person can't afford it, then he must be taking our child for harvesting of organs. Pending criminal appeals, I agree, because I know the status of, because I was the principal judge, so I know the status of all these appeals in various places. But we shall try as much as possible to handle it. Now, the practice direction as such, it was an inclusive circular that when it comes to government projects, we should not injunct them, especially if matters are to do with compensation. We should instead have the compensation paid in court and then resolve the matters of who should take the money subsequently. I think that was our position as courts. I don't know, maybe I'm going to request the judges to look at these matters you are raising. Maybe if you can give them a list, and then we see, because you mentioned a number of projects which have been stopped. the judges can look at them and see whether actually there are injunctions, whether those injunctions can be lifted or whether there are injunctions that must stay, because it doesn't mean that every government project that the injunction may not be given. The circumstances of the case determine. We had matters where, for example, there was a road project when I came in office as principal judge, the Clock Tower project. If you remember that Clock Tower going to Tebe. Some family had applied for an injunction and the court had issued it, and the government was losing 300 million per day. I had to lift it. I lifted that injunction and the project continued. The money was deposited in court. Up to now, they have never recovered it. The money is still in court, they are still fighting. Now you imagine if we had said, let the injunction stay, we would still be having an usual traffic jam. So we must think outside the box on some of these issues. We are saying the government must compensate those who are deserving. But also projects of government must not stall because we are fighting.
Kwasimbere nabi judicial. Nasimbere nabi ofisi ya Chief Justice, Deputy Chief Justice. Kubanga bananga on behalf of Bukuka. Kuba session ya mediation, session ya Court of Appeal. Ifuchiri sana ni Deputy Chief Justice who was saying busango nga bwe bukuka bwe bamasabe buli suppose uba munana mukotita obusanga babusirika mu community ubona aliho ni issues ni buku ati munana ati mediation nasimire nabi ngene hupidise bamasabe ndinga government yaho ere guidance iri mbaho iro mukuka munana mukotita because ari Deputy Chief Justice wa mahulira bulayi bahurikanire barumari fefe bamasaba busango nga buliyo bose babuliyo buna mutondo bose babwira munana basahulu bahole mediation ate fuchitsa n'ukigurira ngabagazeti ngomukuka koramisa mediation ime arenga kwaramisa mediation shina ukano usumbuye bukuka nasima na barumari be bugwere nabo babukobese mu bunana babukobese mu community babumalire so fuchitsa nabi the government through the guidance of the Deputy Chief Justice in the fefe ngabe bukuka. We welcome that directive, we welcome that guidance. Ngawele ngile na adala constitution ye Uganda. Article 126, clause 2D. There are a lot of emphasis on mediations and negotiations. So hukana bandu bahwe sanata RDC na yalo miti.
The Cultural Institution allow me to welcome the Deputy Chief Justice and other justices of the Court of Appeal. I am Stephen Masiga. I am the spokesperson of the Cultural Institution. We have a motto as a Cultural Institution: at when you don't involve us, we will not get involved. I want to salute the Court of Appeal and the registrar here, Mr. Fred, who gave us an official invitation to be part of this engagement. As a cultural institution, we fully associate ourselves with the efforts of government to bring such services nearer to our people. As a cultural institution, we are disturbed with issues of mediation. We had a cultural problem here where we did not have a cultural leader for 3 years after the passing on of Umkuka II. So we are involved in some level of fights here and there until government stepped in to exhaust the problem in the cultural institution using statutorily prescribed solutions. That is Article 246, Clause 2 and Section 16, Subsection 1 of the Cultural Leaders Act that says that when a committee is wrangling on cultural leadership, the elders will sit down and assemble a team or arrive at an appropriate solution. I want to report to court that that is exactly what we did. But however, we get disturbed that after using such a process, the very persons who are part of that process have again ignored that outcome, and they have brought us here to court as I speak. We are invited in Munyonyo the Deputy Chief Justice awarded us some certificate of some training on mediation ADR. And I moved that nobody should make fun of ADR. You can only come and make an appeal in court on grounds that ADR was not followed. But if ADR is a procedural matter and government has fully exhausted or followed those provisions, I wouldn't think it's proper for somebody again to challenge that. Then to lawyers, I've noted very carefully that some of the lawyers who you see them fighting on forums. They carry their battles from court here and they take them on the forums. And I think that's a little bit unfortunate. Let's ensure that we respect court processes and ensure that all discussions should be confined here and not in public domain. We, as parties that have matters here, they shouldn't take such matters outside. As I speak, a team that has brought us here, sued us here, is the very team moving around this community trying to organize an election of the cultural leader, when in essence we have a cultural leader who was gazetted in 23 for a 5-year term. We challenge and rather we appeal to court to ensure that such persons are brought to order, or else it will cause chaos around this country. Thank you so much.
You all, the judges, the gift to serve our country. Two, as a representative of the president here, I just wanted to raise one issue. There is a growing concern that government interests, especially when we are handling issues of land, are not taken in account by our esteemed courts. This year, Mbali district last year, I think, or 2 years ago, lost land in Busano, which it had been occupying since 1994. The government has built their sub-county headquarters. There's a Ketana Gaib, there's staff house for health workers, there's sub-county headquarters, there's a staff house for the sub-county chief. We lost that case. And knowing that until the constitution was made, land before that was being managed under the 1975 land decree. Recently also, we have a project built under the president. It's a strategic interventions. We have Wama in western, central Uganda, we have Wata in northern Uganda, and a Bungoho Mechanization Center in Mbale. That place has been government land since I was a child, since I was cow in Mbale. Now there's a dispute over the boundary. In my view, courts would have allowed mediation. It's being funded by the World Bank. Since 2022, we have a court injunction on that project. It cannot be implemented. Where it has been done, we are halfway. You see the white elephants. This one not only affects government interests, but also affects the services to our people. In Nakaloke, we have land which was for the Ministry of Gender, for the youth, the National Union of Youth Organizations. It's being parceled out. We have tried to use the Attorney General's chambers to sort it out, but we have not received a positive welcome from our colleagues in the judiciary. So I wanted to take this opportunity, my lords, to appeal that while the judiciary is independent, let us also exercise interest for government. Because if we don't have land, if the city do not have land, it will not have anything to give the Court of Appeal. That's my humble request. Otherwise, I thank
the government that land which was given to the district and the government long ago. Now that land is people go to court, even after, like now, Magani Barracks. That land was given, was acquired in 1926. Somebody comes now and says this is land. We have land in Busan. That land, some court has been there since 1994. We lost a case in the court. So somebody says this is land. We have this land in -6 from agricultural mechanization. Somebody went to court and they put an injunction. So the work of government cannot go on. They want to appeal the judiciary. We cannot stop wasting government land, the future investment.
Give us utmost support in our matters, and we expect a ruling within this week or next week probably. But for today's concerns, I know we have prepared a memoranda as the advocates within the Eastern Bar to share with you the most pressing matters that we endure. Key of those, my lord, is the aspect of delay. Delayed justice defeats justice, my lord. We are alive to the challenges that you endure, but 10 years, my lord, is a long time. I'm appearing in this same session. I have a matter which is also as old as 10 years, my lord. One of the parties passed away. The general matter has lost relevance because of that delay. Someone spoke of 20 years that he has been coming to court. We need to do better. We need to serve the public better if we are to make justice accessible. So I would implore you to devise mechanisms to reduce the delay, to address the delay. That is where we are failing the most. My lord, since this year began, we have done a number of engagements with the public. We have been to most of the prisons in this country, and indeed the critical complaint of the members and the public and the inmates is many are serving their terms before their appeals are heard. The last time we had a session here, two of the persons I was appearing for simply told me, no, just withdraw the appeal because I've already served the term. That can't be justice, and we cannot say that we are in a justice system that would administer such a level of justice that somebody serves his term before his appeal is heard. Recall a circular, or to foster the recall of a circular. It is number 2 of 2020. My lord, that circular there limits and restricts the jurisdiction of the High Court to attend to intercountry adoptions. Right now in the regions, we are traveling with the adoptive parents, adoptive and the children to the family, the High Court Family Division to attend to a case of adoption, my lord. It becomes burdensome on the litigant, but also the system. We can't speak about access to justice and then we are telling someone to travel to Kampala, to travel a long distance before they can access that justice. It either speaks of the mistrust we have in the judicial officers or the doubts we have. I don't see why a judge of the High Court sitting in Mbale does not hear an adoption matter and we have to travel to Kampala.